Hello, good afternoon, viewers. Once again, on behalf of MR Solicitors, we are here for our live Facebook session. And today I have our guest, Qazi Mian Iqbal Saab. We also have our partner solicitor, Nazir Naji Saab. And today we have chosen the immigration, points-based immigration system, which has been announced by Priti Patel, the Home Secretary, a few days ago. Even though we have discussed parts of it already, and in my YouTube sessions I have already explained you a few weeks ago that how it will work, but now finally officially they have given a clear table of points how they will work. So we will discuss on those. We will also discuss how the other routes, for example startup routes, innovator, as well as students, and the flexibility for students after completing their qualification in the UK, the work permit visa for 2 years like PSW. And in coming days or weeks, Home Office has also indicated, as advised by MAC, Migration Advisory Committee, that highly skilled work permits will be announced later on after a few months. So let's start with the points-based system. Welcome Naji Saab again, once again. Thank you very much, and welcome Qazi Saab as well. So we start with the points-based system, which the Home Secretary has announced, and it is mostly related to work permit. So we start with that. So Naji Saab, the recent changes we have experienced, even though they are going to be implemented from obviously January 2021 after the practical Brexit. So could you inform us, shed some light on the changes we are expecting or we are going to experience from next year?
Yeah, before that, there is a significant development from Court of Appeal today.
Oh wow.
So I would like to share that development with our viewers. Basically, everyone should be aware of Shamima Bay case, which is quite famous, whereby a British person who went abroad, she fought along with ISIS.
Terrorist activities, yes.
And she was involved in terrorist activities, and she kind of gave some interviews whereby she was in deep trouble, and then Secretary of State withdrew her citizenship. We as a lawyers, obviously we didn't like the idea because she was not given a right of appeal. And there was Secretary of State withdrew her. There were objections that she should be, because she's a British citizen, she should be allowed to come back, and then she should be allowed to fight her case from the UK. So today a Court of Appeal has announced that yes, she can come back and she can fight her case from here. Obviously at the same time, the good thing is the judges have kind of accepted the Home Office point as well, in the sense that the judges are saying the Home Secretary can attach the conditions upon her entry. For example, if they want her to stay in a particular place, in a curfew, or whatever conditions they want to attach with her, they will attach those conditions. But good thing is she is allowed to come back and fight her case out.
That's great news.
Yeah, thank you. In terms of the points-based system, there's a good news. Not everywhere, because there's not a lot of changes, but mainly all the tiers, they remain the same. For example, students, there's not many changes. The only good thing is students who will be starting their courses or degrees from this September onwards, and they will be completing next year, so they will be then eligible for the points-based system, which is a kind of post-study work for 2 years. And if the same student is a PhD student, then he will be given an extra 3 years. Like other changes, they haven't made much. People can come on spouse visas and other stuff. But in terms of there are good news in terms of Pakistani people. especially doctors, nurses, and people who want to come here as care workers. So there is a significant development in terms of that. And the Home Office actually have introduced a points-based system which was already there, but they have slightly lowered the skill level in terms that it was a skill level 6 before, so now they have reduced it to level 3. Basically, if you want to come here on a work permit, you need to score at least 70 points, and in those 70 points there are particular requirements which you have to fulfill. For example, if you have a job offer which is approved by a sponsor which is registered with the Home Office, then you are granted 20 points for that. And if that job is at the appropriate level skill which is advertised by the Home Office, that is another requirement, and if you fulfill that requirement you are granted another 20 points, so your total will become 40 by that point. If you speak English language at the required level, which is the B1 level, which I'm sure any Pakistani or Indian or any other nationality who has done a degree, that person is easily able to achieve that level. So that's B1 level. If you can speak English at that level, you will be given 10 points. So that is easy to score. And then there is a salary threshold. Up to 23,039 pounds, you are not granted any points. So, but if your salary is 23,040 up till 25,599, then you are granted 10 points for that. And but if your salary is more than that, more than of 25,600 or above, then you are granted 20 points. So just with a £1,000 difference, you are granted 10 points for that, and an extra 10 points. Another thing, if the job which you want to come here, if that job is advertised on a shortage occupation list, then it's kind of a lottery for you because you are straight away you are granted 20 points for that. The reason for that is the UK government wants to bring people in who are in demand. So that is a good thing for you if your job is in shortage occupation list. And then if you are a PhD, if you have completed your PhD, you are granted another 10 points on top of that. In regards to PhD, the government has announced that if you have done your PhD in science, technology, engineering, mathematics, and that is related to your job, then you are granted extra 20 points. So for PhD students, it's a win-win situation, and persons who are coming on a shortage occupation list, or you are coming on a job which is advertised at the required level, and your salary is more than 23,040, then you almost qualify for leave to enter the UK, and then you can apply, and then you can come to the UK and serve here. Those are the main points in terms of Tier 2, the work permit requirements. Yeah, that's about it. Yeah.
Thank you very much, Naisab. That was helpful. So as Naisab explained, that they have made it more lenient for those people who would like to come here on work permit basis. There is a little confusion that since they have given more points towards education, and even if you are a PhD degree holder, so you will get extra points, but it doesn't mean that you can avoid or you can omit the points, the mandatory points. The mandatory points you have to gain, which are like 50 points for an example, which are going to be from employer. So you have to have a sponsored employer. If you do not have a sponsored employer and you are thinking you are going to make 70 points without it, which it seems possible if you look into the education and the salary points, it's not going to work. So 3 areas are mandatory. For an example, you have to have a UK sponsored license holder, a sponsor employer.
Yeah.
Secondly, you have to have English requirement met.
Yeah.
And thirdly, the required skill level. The skill level they have reduced, as mentioned, from level 6 to level 3, which is a huge decline. Level 6 means like a degree level. I'm talking about UK standards. And level 3 means like A levels. So if you have experience in your country of origin up to A level equivalent experience, that is RQF level 3, you will be eligible, which was not the case before. So this is a huge change in work permit category. So those people who have a lower level of experience, they can still come in. And then obviously the huge change is in salary. It has been reduced to £23,000, 23,040 to be accurate. So if the employer can pay you minimum to that level, but if the job which is offered is from shortage occupation list, then you can even pay the employee less than 23,000. You can pay up to minimum of £20,000, 20,480 to be exact. You can pay if the job falls in that category, because you will be getting extra points from that category. So there are huge changes in terms of the experience and in terms of salary sectors. And obviously if you are a PhD holder and if your degree is relevant to the job, then you have extra points. And if it is from science and technology or English or maths, then you get extra points as well. So very favorable to those people who would like to come, and this is going to be implemented from 1st of January 2021. Other changes in relation to mobility scheme and all that is pretty much same, but they are not very much relevant to subcontinent countries. But if you have any specific question in relation to any other country, please do send us email on info@m-rsolicitors.co.uk. We also have some questions in front of us which were sent by email. We are getting some probably inquiries on Facebook as well, and we will try to respond. If you would like to make an appointment with us and have face-to-face appointment, which we have started, or even Skype appointment, you can call us on 0208 518 1956. If you're calling from overseas, obviously you will call 0044 and then 2028 518 1956. Naisa, we had one question which was received by email, and that question is interesting one. For example, a person who came here and he was married before, and after coming here, due to some reasons, he got divorced, or he gave divorce to his first spouse, who was overseas, not here, and even though he did have 1 or 2 children from her, then he didn't get married here, but on the basis of partnership, living together for 2 years or more, or probably because of religious marriage, he got another child here who's British national. Initially he did get the visa under 10-year category because he became an overseer, and then he applied and he got this 2.5 years visa under 10-year category. Then what happened, that there was a separation between them as well. So then he applied for extension, and he got extension because of child, because child is British. So he maintained his contact with the child, and his visa was extended for another 2.5 years, again under the 10 years category. Now when time came for third extension, or rather second extension but third term, what he did is he completed the form under parent route category, the 5-year parent route category. And what he did is he did his English test, and he ticked that, rather than he taking the family life or the private side life under the 10-year route. He ticked that 5-year route category, and Home Office has granted him that parent route 5 years visa now. So he has switched to 5-year parent route category. Now the interesting situation is that he has made up with his first wife. He went back, say last year, and he got that nikah done again. And it's registered again. So it was divorced, then he got nikah done with her again.
Yeah.
But because there was no registration or official marriage in UK, so he didn't have to go through the divorce with this wife.
Yeah.
So now what he wants to do is he wants to apply for that wife and child who are overseas. So obviously he does not have a settled visa in the UK.
Yeah.
He doesn't have indefinite leave to remain.
Yeah.
So obviously if he doesn't have an indefinite leave to remain here, he cannot call her on spouse visa. Because the first requirement is you have to have a settled status,
Yeah.
which he doesn't have.
Yeah.
Indefinite he doesn't have nationality, he doesn't have refugee status.
Yeah.
So he is on limited leave as a parent.
Yes.
So under what category he is going to sponsor his wife? If it is going to be just a human rights general category, Article 8, and if it gets refused, my understanding is he will still get a right of appeal on that. What sort of fees he will be paying there? Whether he will go through the income threshold as applicable to on spouse visas. What about the lady wife there? Does she has to go through the English test as well or not? So this is very interesting situation.
Yes.
So I wanted your opinion as well on that. Thank you.
Thank you very much. Quite a complex situation. And basically, what I would say is that there is no such category of application under which his situation falls. For example, he's not settled here. He himself has a limited leave, albeit on the basis of a parent route. On the basis of a parent route. So he still has a limited leave to remain in the UK. What we have done previously in cases like these is there is a Home Office policy that they assume that you should be at least, for example, if you have been given settlement under European route, you are a settled person here, and that settlement was gained either by completing 5 years or by completing 3 years if you were divorced, and now you are a settled person in terms of immigration rules. So now you are married back home, for example, and now you want to sponsor your wife. So even in that sense, there is no category whereby that person is able to sponsor his wife, because he, in terms of pure settlement, although he is settled in this country, but he doesn't have indefinite leave to remain.
Yes.
But now the Home Office has covered situations like these, whereby they are saying that, okay, because you have got settlement which is equal to indefinite leave to remain, so on that basis we are treating you for the purposes of immigration rules as a settled person. So on that basis, those persons or their spouses need to make an application on settlement, and they need to fulfill all those requirements. For example, the sponsor has to be working in the UK, earning at least 18,600 if he or she wants to sponsor a person. But in this particular case, what I would advise, which is in line with the Home Office policy as well, that the overseas applicant should be thinking in terms of as a spouse. So she should be aiming to fulfill the requirements of a spouse as a settled person. The reason being that is that, for example, if that person is refused, that person is given a right of appeal because Article 8 is involved, and we go before a judge. And when we go before a judge, the Home Office normally raises this question that first of all, there is no such category that this person is able to sponsor someone. And now if he has gone on to sponsor someone, and if we apply less stringent requirements on this person or his spouse than a European or British national, then that goes against our own policy and rules and regulations. So that's why our advice would be to aim and prepare an application and provide the evidence assuming that that person is the spouse of a settled person. And obviously our application will be made under Article 8, and that's about it.
Thank you very much. Yes, I thought so. So the application is going to be under Article 8 because unfortunately, since you do not have the settled status in the UK, so spouse visa application is not going to work there. And because you are going to make an application under Article 8, if they do refuse, then you will get right of appeal. There's another suggestion that, okay, if she applies for visitor visa, yes, definitely she can apply for visitor visa, but for some reasons, if that visitor visa gets refused, there is no right of appeal. So it would be better if you apply under human rights grounds. So even if it is refused, you will have right of appeal, and you may stand better chance to go and fight in the appeal in front of judge, because under human rights, the judge will have some sort of discretion and more powers under Article 8, because it's quite a factual situation here, not only legal. So it will depend case to case. It will vary. The situation varies case to case. The emotional circumstances, the attachment. Let's see if this child, which is in UK, if the child is staying with you, and what type of connection he has with your wife in Pakistan. If that connection can be established, she becomes stepmother. So if she does become stepmother of this child, then there is another category, child access route. So because if the child is British, then you can go for child access route. Now that's another way out.
Yeah.
That if the person here is obviously married, which is recognized, which I believe is recognized marriage, so then this child who's a British national becomes gives a route of child access to the mother. The stepmother in a country like overseas can apply under that category as well. So I would advise that if you can see your advisor, or come to us and see us face to face, and we can consider your circumstances in much detail, and then advise you accordingly. We have few questions as well. There's one short question about stamp duty, because there has been an announcement on stamp duty waiver kind of thing. So first of all, you need to know whether you are a first-time buyer or not. So if you are a first-time buyer, then yes, the exemption applies to you. There is no stamp duty up until the limit is 500,000. So if the property worth is 500,000 pounds or less, you don't have to pay any stamp duty. But if it is above, then you do you pay 3% on that. And but if you are a second-time buyer, you are not a first-time buyer, then obviously it is there. So you will still pay the stamp duty. However, it is going to be 3% on your second property. So the upper limit is 925,000 pounds, and then the threshold goes a little more above. But again, in your personal circumstances, please do take advice accordingly. There are more questions we are having, which we will be trying to answer. Shall I take one or two questions, Imran Sahab,
yes,
or shall we come to you first? I'll take at least one question. So there's a question, Mansoor Imtiaz Khan Sahab, welcome first of all to our Facebook session. Your question is tier 4, okay, tier 4 means students. They have applied under European settlement scheme and as extended family member, and they were granted with the dependency proofs, and they were granted some kind of leave. But many other people say that a person in tier 4 cannot apply directly under this EU settlement as an extended family member. He must apply for residence. Okay, well, I give you a general scenario, and I'm sure you will find your answer in there as well. So whoever, whether it is tier 4 or not, or visitor, or even without any leave, if you can fulfill the requirements of regulation 8 of EEA or regulation 9, if your sponsor is a British national and has spent some time outside UK in your European country and has come back, and you have spent time with that sponsor outside UK as well, this is for regulation 9. And for regulation 8 in this country, you can apply for normal Regulation 8 category, not under the European Union settlement scheme. No, you cannot apply. So people who are telling you that we have applied and we got it, you need to ask them, okay, can they show you that? So if Home Office has made a mistake in one or two cases, that's a separate issue. But the general criteria is you cannot apply unless and until you have received initially the resident permit from UK under normal Regulation 8 category, and the forms you must have used is EEA, EFM, Extended Family Member, or even FM Family Member depending on your circumstances. So if you have been granted that visa even few days ago, you can go for pre-settled, online, or settled again depending on your situation for how long you have been staying with your sponsor. So if someone is telling you something else, what I'm telling you other than that, then you need to ask them to give you a proof. And if you have 2, 3, 4 cases like that, then use that as an example, as a precedent, and send your application as well to Home Office. And if they refuse, then you can go against them. But I doubt it very much. So the general information is there, and I hope I've answered your question as well in between. Soban Javed, welcome again. So you have your EEA2 visa. It's in Urdu, so I'll try to respond in Urdu. मेरा वीज़ा कोरोना के दौरान पाकिस्तान एक्सपायर हो गया है 2 जून को, कैसे ट्रैवल करूँ? Okay. So if you were in Pakistan under EU regulations, you could have stayed there up to 6 months. But if your visa was expiring before 6 months, you're supposed to come back. However, if your ticket was booked before expiry of the visa within 6 months, and because of Corona you could not travel, you have to email to Home Office for visa waiver. And they will confirm to you back with that email that we are granting you visa waiver, and you will tell them when you are traveling. With that letter, you can travel, you can enter UK as you're supposed to enter with the visa. So if because of coronavirus, if you can prove that because of that you could not travel, you had your return ticket booked, but you could not travel because of this pandemic situation, you will email them and they will confirm visa waiver letter and you can travel back. There'll be no problem.
इनको उर्दू में भी explain कर.
Sorry, I supposed to. मुझे उर्दू में explain करना चाहिए था. माजरत. So आपका अगर वीज़ा वहाँ पे ख़त्म हो गया है, आप पहले बात तो ये जहन में रखिए कि आपको 6 महीने से ज़्यादा रहने की इजाज़त नहीं थी. अगर आप वहाँ पे गए हैं और 6 महीने के अंदर अंदर आपने वापस आना था, आपके पास रिटर्न टिकट थी, लेकिन इस पेंडेमिक सिचुएशन की वजह से आप नहीं आ सके और आप 6 महीने के अंदर अंदर ही थी रिटर्न टिकट, तो अब आप उनको एक ईमेल करेंगे और ईमेल के होम ऑफिस को, और उसके नतीजे फॉर वीज़ा फ़ी वेवर, यही आपने जो इन्फॉर्मेशन मुझे दी है उन्हें देंगे अपनी डिटेल के साथ. वो आपको दोबारा ईमेल विद इन फ्यू डेज जवाब दे देंगे कि जी आपको हम एक्सेप्ट कर रहे हैं. आप उस ईमेल की बहाफ के ऊपर उधर से ट्रैवल करके यूके आ सकते हैं और यूके में भी आपको वही ईमेल दिखानी पड़ेगी, लेकिन वो अपने सिस्टम में चेक करेंगे तो आपका नाम निकल आएगा एंड देन यू कैन एंटर. आप एंटर हो सकते हैं यूके में अगर आपका वीज़ा एक्सपायर हो भी गया है तो. और ये सिचुएशन चल सकती है दिसंबर तक, ये भी मैं आपको बता दूं, क्योंकि दिसंबर इन्होंने ब्रेक्सिट की डेट रखी हुई है. लेकिन इसका ये मतलब नहीं है कि आप जानबूझ के वहां बैठे रहें. आपको स्टिल ये साबित करना पड़ेगा कि मैंने ट्राई की और मैं क्यों कामयाब नहीं हुआ, क्योंकि मेरे अंदर सिम्टम्स थे या फ्लाइट्स अवेलेबल नहीं थी, जो वाकई कोविड की वजह से जो है. क्योंकि यहाँ पे भी जो उन्होंने एक रिलैक्सेशन दी हुई है 31 जुलाई तक की, वो भी इसी वजह से दी हुई है कि आपको अगर आप जा नहीं सके, ये नहीं आप कह सकते मैं आ गया हूँ, मैं अब जा नहीं, मैं वीज़ा अप्लाई कर रहा हूँ, मैं स्विच कर रहा हूँ या मुझे एक्सटेंशन देनी. आपने ये कहना है कि कोविड की वजह से मैं नहीं जा पा रहा, तो उस बेस पे आप कैटेगरी अपनी स्विच भी कर सकते हैं, जिसके कुछ क्वेश्चंस हमारे पास आगे भी हैं और हम उस पर भी बात करेंगे.
ये ऐप से भी यूज कर सकते हो, ओवरसीज ऐप कैन बी यूज्ड.
विच ऐप? सॉरी,
प्री सेटल स्टेटस की.
यस. और दूसरा, आप अगर वहां बैठे हुए थे, अगर आप यूरोपियन है तब भी, और अगर आप यूरोपियन डिपेंडेंट हैं तब भी, दोनों सूरतों में जब आपके पास ऑलरेडी वीजा था तो आप प्री सेटल्ड वीजा अप्लाई कर सकते हैं अभी भी. तो आप प्री सेटल्ड जब अप्लाई करेंगे तो वो तो आपको वैसे प्री सेटल्ड मिल गया और वो 5 साल के लिए वैलिड है. आप फिर और भी कुछ अर्सा रह सकते हैं एज लॉन्ग एज विद इन 6 मंथ्स. सो वेरी राइटली पॉइंटेड आउट. तो ये ऐप जो है, जब आप अप्लाई करते हैं यू सेटलमेंट की ऐप के ऊपर, तो पहला क्वेश्चन पूछता है आपसे कि आप यूके में हैं या यूके के बाहर हैं. लेकिन इसका ये मतलब नहीं कि यूके के बाहर रहने वालों को वो नहीं मिलेगा. वो आपके एनआई नंबर से आपका सारा टैक्स का रिकॉर्ड चेक कर सकते हैं. अगर वो कोई चीज मांगे आप उन्हें अपलोड कर सकते हैं. तो आप अपना वीजा वहां बैठे बैठे प्री सेटल्ड में ले सकते हैं जो 5 साल वैलिड है. तो फिर ये सवाल आपका बनेगा नहीं, यू कैन स्टिल कम बैक. लेकिन ये उन लोगों के लिए भी है जो स्पाउस वीज़े पे गए थे, स्पाउस वीज़ा उनका वहाँ गए और वापस नहीं आ सके, उनके वीज़े एक्सपायर होंगे, तो ये जो मैंने एडवाइस दी है ये उनके काम भी आएगी, उन्हें वीज़ा वेवर मिलेगा एंड वो वापस आ सकते हैं. थैंक यू इमरान साहब, ये बहुत ज़बरदस्त आपने पॉइंट जो है बताया है एंड आई एम होपफुल कि बहुत से लोगों का इससे फ़ायदा हो गया होगा. राइट, सो सुभान साहब, होपफुली मैंने आपका जवाब दे दिया है और उम्मीद करते हैं कि आपको जवाब जो है वो समझ आ गया होगा. इस पे अब एक और जवाब हमें सवाल है आयशा कमाल साहिबा का. वेलकम जी. आप कह रही हैं कि आपके कोई फ्रेंड हैं जो यूके में रह रहे हैं 19 साल और 7 महीने से, उनकी तो उम्र कैद ऑलरेडी पूरी हो चुकी है. तो his last application was refused about a year ago. I want to ask if he can apply now or he has to wait full. Okay. देखें, एक तो कैटेगरी 20 साल वाली बड़ी क्लियर है, तो उनके 5 महीने बाकी हैं, 5 महीने वेट करके वो एप्लीकेशन देंगे 20 साल की बेस के ऊपर, लेकिन 20 साल साबित करने बाकी भी हैं उन्होंने, तो उसकी बेस पे उनको स्टे मिल जाएगा. लेकिन इस वक्त जो होम ऑफिस की सिचुएशन है, हमारे पास एक लार्ज नंबर ऑफ एप्लीकेशंस हैं जो हमने 17-18 ईयर्स के ऊपर भी भेजी हैं और हम कामयाब रहे हैं उनका स्टेटस लेने में. वी हैव बीन सक्सेसफुल गेटिंग लीव्स फॉर देम. सो इवन इफ ही अप्लाइज नाउ बट telling that why he cannot go back, there are 3 main factors the home office is going to consider: your social life, your family life, your economic life is not anymore present in your country of origin. It's all here and you make an application. But considering the situation, home office is approximately going to take 6 months anyway. So if you're making an application now or after a few days, you are going to get biometrics. By the time they will decide, it will be 6 months anyway, and so you are going to get it anyway. So it's your choice basically. You can apply now, you will get it. You can apply a little later, you can get it as well. I hope I have answered your question. Guys, thank you for sitting there patiently. So the situation as it is, you normally give us information on asylum. I know there is no announcement yet. There is no amnesty yet.
Yes.
People every day ask us that, okay, is there going to be any amnesty? But what I have experienced, and many other lawyers have experienced, and some people, they have openly said this on social media, that there is no amnesty, but actually there is amnesty, and Home Office has started granting status to those people who have been here for a long time, and they are sending their valid cases. So as I said just now, the 20 years case as well, that this is true, that Home Office is taking things leniently for those people who have been here for a long time, but again, they can show that if you grant them leave, they will contribute towards UK economy and all that, so with your business plan, with your family life and all that. So in relation to asylum, do you think, is there going to be any amnesty, or Home Office is considering that, or their behavior has changed towards asylum cases, or what type of asylum cases are going to Home Office these days? Which categories are being used by the applicants more these days?
Thank you, sir. Basically, recently as these development came across with the Hong Kong situation, and one of very responsible government official, I don't know whether it's a policy or his personal statement, but they announced that they are going to issue thousands of people from Hong Kong the British residency.
Yes.
And which created a panic situation or the debate situation in the House of Commons. And then obviously the other parties, especially the few prominent Labour Party leaders, they raised the issue that if you want to bring overseas people and give them nationalities and overseas people, you are obliging. So why can't you give millions of people who are already slided in the UK, and majority of them, they are working in the UK black economy and they are facing exploitation. So why can't you settle those people? So yes, it's not any official announcement or the policy, but as I can assess that might be they announce something in the light of recent developments about the Hong Kong situation, and they take seriously about the voices raised for the people who are already here and their situation in their human right application, their asylum claims are pending, and they are stuck in the same situation from over the years and years. Like you are witness yourself, like so many people, their cases are stuck in the Home Office from last 3, 4, 5 years, even more than that. Some cases we are witnessing that they are stuck in the Home Office over the decade.
Yes.
So probably the people get good news because of these voices which now started coming along with the government circle as well, that settle these people rather than to bring the overseas people here in the UK. So it could be a good news.
Thank you. So there are news, and there are so many organizations who deal with refugees as well and overseas people, and they have been voicing and they have been writing to the Secretary of State as well, that do consider those people, and there is an estimate that up to 1 million, nearly 1 million people in this country are without leave, without status. So, and many of them maybe are with they have skills, and many of them have those skills which are required by the UK economy, and many can be adjusted in NHS. They are care workers, they are qualified nurses, they are qualified doctors, but because they do not have status in the country, they cannot get advantage, and NHS cannot get advantage. So even if they're working somewhere in black economy, they are not paying taxes. So it would be wise to make a decision on these basis, that if you give them right to stay and they are working, obviously they'll be paying taxes. So yes, there are voices, and let's see how Home Office react upon them. But until now, as we speak, there is no official announcement yet. There's another procedural change in relation to asylum about the screening interview. People, when you're making an asylum application, the procedure has been recently that you call them in advance, and they take some biodata information, basic information, and then they ask you to come to Home Office. And once you go to the Home Office, then there's a detailed screening interview, and they take your biometrics, and it takes about 5-7 hours sometimes in the Home Office. I heard that there is a slight change in that.
Yes, sir. Actually, it's a change in the substantive interview as well and the screening. So now they made it easy. Initially, whoever want to claim asylum, they need to call Home Office to book an appointment. But now the appointment itself, it's not for the interview, it's just for the biometrics. When someone calls, they interviewed him very next day. Obviously, they give 10 days time, but in the most cases they called second day or even the same day, and they screen people on phone.
Right, okay.
Yes, and then they call the Home Office, they just issue, they record their biometrics, they just issue the paperwork, and they send them back. And further to this, the substantive interviews are also, they are taking via Skype. There is no in-person presence, but obviously the person has to be in the Home Office designated room or their venues. Some of the cases they hired venues in central London or different places of the London, and they hired that one, and they screened, they interviewed on the Skype rather than in person.
But they're still asking you to come to their center.
Their center, just in order to avoid any proxy or anything else.
And collusion, and you can't do, you can't collude actually. Okay. So similarly, the immigration hearings, the court hearings, they have introduced again, which used to be case management review hearings some time back, but then it was all abolished. They just used to do on case-to-case basis, but now that system has come back due to pandemic situation. So they do that over the phone, and the judge go through the issues of the refusal letter with the appellant's lawyer as well as with the Home Office, the respondent's lawyer, and then they try to narrow down the issues, and then the hearings have started coming back, but they are going to be on Skype for the time being. But if it is going to be over Skype in the long run, I fear that is not going to be the good for appellants. At least the due process of justice is not going to go through smoothly, because it'll be difficult over the Skype. It's not as good as face to face, but let's see how it develops, how the system develops. So we have started getting hearing dates from probably October onwards, November onwards, I believe.
Yes, we are.
Yeah, November onwards we are getting these Skype dates. At the moment they are doing all case management review hearings over the phone, and they are trying to stick to deadlines. So far Home Office is not so good in keeping the deadlines, so there is further delay. So the whole situation is little out of control by the court and Home Office, but we are hoping that it will get better. Another question we had, Naji Sahab here, probably it's a straightforward question, where the question is, you got indefinite leave to remain for over a year, and now you want to apply for nationality, but in 2013, probably for some time, you have been an overstayer. So how that will affect whether you can make an application now or not, because 10 years, the good character thing can come up.
Yeah, I mean, normally people are allowed, once they have been granted indefinite leave to remain, after 1 year of that, you are eligible to apply, but then you have to make sure that you fulfill the requirements. And one of the requirement to be granted naturalization is that you must be of good character.
Yes.
And since he has disclosed that he was an overstayer in 2013, according to Home Office policy, they might be of the view, or they will be certainly of the view, that because he was an overstayer just under 10 years, so they will probably refuse him. So we will advise him not to make an application at this moment in time. Wait for 10 years, which is 2023, and if then he applies at that time, and if he fulfills the requirements at that time, then he will be granted naturalization.
Yes, it's straightforward these days. It's very, very unlikely that the Home Office will grant you nationality, because there is issue of overstaying, and if it is over 28 days in 2013, they are going to very, very likely penalize. But it is always a discretionary matter. So if you have compassionate grounds to fight that gap, if there were medical reasons, for an example, and because of that you could not give an application to the Home Office due to your medical reasons, compassionate reasons, but otherwise you have been staying legally in this country, so that discretion can be exercised in your favor. But generally speaking, a general advice is that it has to be 10 years legal, otherwise they are penalizing people and they are refusing. There's another technical question which is related to nationality, that people who get indefinite leave to remain on the basis of marriage, they spend 5 years here and they got indefinite leave to remain. Now the general criteria is that you have to wait for 1 year and then apply for nationality. However, in this particular category, if your spouse on whose basis you got this indefinite leave to remain is already a British national, not an indefinite holder or refugee, a British national, then you don't have to wait for 1 year. You can apply nationality straight away. But as long as you have spent 5 years and 10 years and the English requirement is there. Otherwise, you have to wait for one year for indefinite leave to remain, and the holiday period has to be within the limits, 90 days and the 500, is it 60?
560.
450.
450, sorry, 450 in last 5 years. If you have spent less than that time outside UK, then you should be able to get that. There's a question, probably we'll take this last question, and if there are more questions, we'll obviously respond to you later on, and you can always email us on info@m-rsolicitors.co.uk. The question is, what about EU settlement scheme? If a person has pre-settled and get divorced, will he lose his right to stay? Not at all. But Nahisa, if you want to respond.
Interesting. We are getting a lot of queries on this. I think the basic position is, if you have been accepted as a family member and you have been granted a stay on that basis, albeit it's a pre-settled stay, that should continue. Once you complete your 5 years, then you should be eligible to apply, and then you will be granted settlement on that basis. But if your circumstances change, which is beyond your control, then obviously, like there are in current law, there are exemptions available. So if you have a particular circumstance, then you can explain that to the Home Office, and then certainly they will take that into account. Apart from that, if you complete your 5 years normally, then you should be able to get settlement at the end of it.
Yes. The other way, you did not mention the dates. When did you initially obtain your EA residency, when you got married? If there is a gap of 3 years of visa and a divorce, obviously you can still change your status and retain right as well.
Yes.
So that's another category you have to rely on depending on the circumstances and if there are children or not. So as I say, that we can only give a general advice here unless we know the full facts, which is difficult to know on messages. So either you email us or take an appointment and see us. Our office number is 0208 518 1956, or as I said, email us on info@m-r-solicitors.co.uk. There was a detailed inquiry on startup and innovator visa, so I will respond to you, sir, via email. However, just before we leave, innovator visa is suitable, more suitable for those people who are fresh graduates. They have innovative business plan, whether they are here on student visa or they are not here on student visa. If they are here on student visa, it's very, very likely the degree they have done from the university, that university is in the list, endorsed body list. So they will get the visa, the business plan endorsed from their university and apply and get startup visa. But if you are abroad, you cannot get your degree is not from here, then still there are universities and other bodies which will consider your business plan, and accordingly if they endorse, you can still go for it. So that is for fresh graduates with an innovative business plan. The innovator visa is similar visa based on innovative business plan. You don't have to have a degree, however you have to have experience in relevant business plan you are giving, with the investment of £50,000 at least. Okay, yes, you can add your dependents, which is your spouse and under 18 children. The difference again between two is the innovator visa is for 3 years, and if you continue progressing on your business here in the UK, and then after 3 years you would be applying for indefinite leave to remain. If you cannot progress and it's less than the threshold, then still you will get extension for 2 years or more, and then you can go for indefinite afterwards. Whereas startup visa is going to be for 2 years, but you can after 2 years switch to innovator visa for 3 years and then qualify for indefinite leave to remain after 5 years. The inquiries about sole representatives, again, the basic rule of the thumb is that you cannot apply as a sole representative of overseas business if you are the sole or majority business partner of that business overseas. You cannot. You have to be either minority partner, less than 50% shareholding, or you are an employee but in a higher management level where you have decision making power and all that. And yes, you will get visa as well with your dependents under 18 and your spouse. Again, for specific inquiries, please email us and we will try to respond on those. If there are any questions left on this Facebook session messages, then we will try to respond that as well. Until next time, stay safe and look after yourself and others. And I once again thank you very much, my colleague Nazir Naji Sahab, our guest Qazi Ibrahim Iqbal Sahab, and all the viewers who took time and watched our this session, and my professional friends who do take time out and come back with good feedbacks. Thank you very much. So next week or next time when I come within the next 10 days, there will be a guest and we will be discussing on financial matters. So if you are looking for commercial mortgage, you are looking for C-bills, buyback loan, or any information in relating to that, we will have our qualified guest with us, and you will be able to ask questions, or you can send us questions in advance. So thank you very much once again. Take care. Bye.